Class is now starting. All attendees are in listen-only mode.
Okay, good evening. I believe we're online and recording. I just can't see where it is. Make sure I'm sharing my screen. Okay, so I'm on air. My screen should be showing. It should be recording, so we should be ready to go. Got my friends and family on Facebook here. I don't have anybody on Twitter or YouTube because the iPhone sucks. But nonetheless. So good evening, or whenever you happen to be watching this, good day. My name is Brad Micklin. I'm the attorney and managing member of the Micklin Law Group. We are a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley and Montclair, New Jersey. Today is my monthly webinar series where I try to go much deeper into a topic than I do with my daily tips and my weekly how-to videos. Really cover something in depth and give as much advice as I possibly can. The intention of the webinar is to last about 50-60 minutes with a question session at the end. I go as long as it takes. I don't know how long I'm going to talk on each topic. This is a topic that does have a lot of law to it, but there are a lot of issues and signs I want to give you to look for and keep an eye on so that if you do see it developing, you'll be well armed in advance. Those that are watching on my GoToWebinar should have a chat panel or a control panel on the right side of your screen, and that will have a chat section and a question section towards the bottom. I usually recommend you use the questions and not the chat because I don't check that. And you should post questions you have when they come up to you, but I don't address them until the end just to keep the flow going. I also attached to the control panel in the handout section a copy of this PowerPoint, so if you're interested in downloading it, it'll be there for you. Quickly, just looking over to Facebook. Yes, I never tell anybody by name they're on, but the person who asked if they're on the air, no, you're on my Facebook. I think only people that can see you when you're watching are people that are joint friends of both of us. So there's still a little bit of confidentiality to it, but not a great deal. So if for some reason Facebook isn't really the forum to use, if you want to keep it private, you would be better off signing off and going to my website and signing on through GoToWebinar. So let's jump into it. All right, so to those that don't know me and that are watching on my webinar, this is me. I am a licensed attorney in New Jersey, state and federal courts. Used to be licensed in Pennsylvania. I retired there, technically, because I just don't think you can do more than one state very well. I founded the Micklin Law Group in 2000, I think it was. Originally, I was a general practice attorney, and I quickly focused into family law and custody issues, and then shortly thereafter began a concentration, well, actually, maybe a handful of years ago now, into men's and fathers' rights. The reason for that, in case you're interested, is I believe that the laws are changing significantly for men and fathers, but I don't think the attitudes are, both of the other parents and the judges. So I think there needs to be people willing to stand up and say things like men should get alimony, men should have custody, that they are equal when it comes to divorce issues. But that's my soapbox, not really relevant to today's topic. And here I put up a handful of awards I've been honored and lucky to receive, not to try to impress people, but to impress upon them that I do have a great deal of experience. I've been doing this for a very long time, over 20 years now. I care a great deal about what I do, and hopefully it shows in the work I do as well as these awards I've been fortunate to receive. Next is a snapshot of some of the appearances I do. I'm a media consultant for many different national television shows and news reports. Again, this isn't to try to impress people, but just to let you know what I do and that people do rely on me for various opinions and legal work outside of what I do. But enough about me. Let's jump into the content. Now, we're going to start first, before I get to the actual questions, talk about many of the signs and symptoms of parental alienation, because it's a problem. It's a very serious problem. You wouldn't be watching this if you didn't understand that already. But there are many different facets to it, and it develops over time. So you really need to be aware and prepared as you go through and as this develops to attack it as early as you possibly can. There are going to be many issues and signs that I'm going to show you, so bear with me. It may take up a good portion of the broadcast, and it may even be tiresome to some of you to listen to all of this, the reading basic points, and may be hurtful to others that are going through it, but it's really something important for you to know. So the first is, and these are all going to be signs from the child or children, not necessarily from the custodial parent or the other parent. Extremely negative views towards the other parent, denying past positive experience, and not having an interest in a relationship. It's normally unusual for a child to persist with that. Often that'll be a sign in the middle or in the beginning of a divorce, but it usually passes. The upset will pass and they acclimate to the change. If you find that these negative views are persisting, there's something more than just upset over the change in the family structure. Next, children making absurd allegations about being hurt and angry with the other parent. Again, it's very common and understandable in most circumstances for a child to be upset when these types of matters are up. But you want to look when something is beyond that, which is the purpose of this video, is to see when it is and isn't beyond that. It'll be mixed with other symptoms. Dealing with parents as black and white, meaning all good or all bad. The custodial parent obviously is usually the all good, and the non-custodial cannot do anything right. When you see this start to surface, you know that you're moving in a direction where alienation may be occurring. Additional views, additional signs. Always siding with the custodial parent. Now, on the slide it says favored, but it's usually going to be custodial, so I use them interchangeably, regardless of what he or she says or does. There's never a child that supports everything their parent does. So when you see that happening, you know that we're gliding into this zone. A lack of care or remorse for the fact that the other parent, you, who would be watching this, is being hurt and upset by the alienation or the actions of the child. Claiming to reject the parent and also claiming that there's been no influence from the other parent in that rejection, that's just not realistic. Children generally want to believe that their parents are superheroes, which is why they often get hurt when one parent talks badly about the other. If you see that that's starting to change and they're claiming it's on their own fruition or choice, that's not likely to be the case. A couple more for you, again, because I think seeing the signs would be the most important first step in addressing the problem. Repeating verbatim things that the other parent says, even though you have a strong belief that they don't understand what they're talking about. They quote words, and we'll get into this again, but if you hear them talk about legal terms or custodial terms or sophisticated terms, you know that they're getting it from the other parent, but they're trying to incorporate them and act as if it's their own. And then lastly, when the alienation starts to expand and they become hostile towards your friends and family, it becomes a situation where it's almost nothing that you can do is right, so everybody you're associated to is evil or bad. So these are the most common. Obviously, there are countless others, but these are the most common that you want to look towards and take a note of when you see them starting to develop. From time to time, I take a second out and I check in the Facebook, see if anybody new is signing on, that there's a hello. And like I said, I always say to everybody, other than my wife, who I love and happy that she supported me by watching this, that I never recognize anybody by direct names because it's still kind of confidential to the people that are on my Facebook. If you're not friends with the other people, they don't see you. So only people who see you are joint friends. So I love the support of everybody. I don't always say hello to anybody other than my wife because I don't want to disturb anybody's confidentiality. So let's move into the questions, which we came here for. First one is, how do I know if my child's other parent is attempting to cause alienation? Now, and we'll touch on this a little later, it's not necessarily that they're trying to do this. We'll get into the psychology towards the end of the webinar, but sometimes it's unintentional. More often than not, it's unintentional. Or not, I shouldn't say unintentional. It's not their goal. It's not their action. They're operating from an unconscious desire to cut the child out of your life. Not that that makes it any better, but it makes it less, it's not intentional. So typical signs. First would be when the parent tries to convince the child or advocate in the court or to you that the child has the right to make a choice about parenting time or custody. No child ever has the right to make this kind of decision. And people ask me this all the time. When will the court listen to my child? When will they bring them in for hearings? And the simple answer is they'll never, ever let a child make this kind of decision. First, they don't want to put a child between two parents and have to make a choice. And two, no child is able to make that sophisticated decision. I had a case where I had a 17-year-old girl who was in college, so she was unemancipated, which means she wasn't a legal adult yet. And there was a custody issue because it dealt with where she was going to stay over breaks and summers and who was going to pay child support and college contribution. And the court wouldn't take her opinion either because, for those two reasons, it's not good to put her in the middle, and it's a difficult decision for a 17-year-old. It's a difficult decision for a 27-year-old. Now, to answer the question that people always ask, at what age will they listen to, they'll start to value the opinion, is usually around 13 or 14. Early teens, they'll start to listen to the opinion, but they will never accept it without more support or reasons for it. You'll notice when you're having parenting time that the child is not bringing personal items back and forth. They're either leaving it at home or they're requiring that you purchase it at your house. It's a sort of control. It also eliminates how good of a time they're going to have with you. If their iPad, for instance, is at home and all their games or their social contacts are there, it's a way to keep the child from enjoying the time. Next, I touched on this before, is providing the child with information about the divorce or custody hearing. That's poison to a child, always. And there's not a judge that I know of in this state or any other that would condone that. The backlash from that is astronomical, but it's often difficult to prove unless, as we talked about a moment ago, they're using vocabulary and words that they would never know or otherwise get other than from the parent. Absolutely, it's poison. So it's probably one of the first signs that you're going to see that you need to step in. All right, so let's look at some more typical signs. Blaming the target parent for the breakup. Target means like the non-custodial parent. For the breakup, for money issues, for any other problem that the child may be experiencing. Change in homes, change in schools, change obviously in the living arrangements. All is blamed on the non-custodial parent. That is never the case in any circumstances. It takes two people to ruin a relationship, but neither should be trying to convince the child that it's the other person's fault. Next one, and this is a big one that starts out early, is scheduling events during your time because it forces the child to have to choose between the two, and usually they're going to want to choose the activities, and many parents that would be in this circumstance aren't going to force the child to give up his or her activity because they want their children to have fun and they know that there's going to be upset. So they'll acquiesce to this thinking that they're helping the situation, but you're not. Trust me. You're actually reinforcing the bad behavior of the other parent by doing it. And all of these things I'm talking about, when you see them, you should not be ignoring them, thinking that you're actually gaining favor or reducing your problems. You're actually just doing the opposite when it comes to alienation and issues like that. Next is having the child provide information about you. And I say you because if you're watching this, it's because you assume that you are going to be or are being alienated. So when the child comes back, sometimes they'll record conversations on their phone because that's not hard to do. They'll give information. Those are usually the most common ones. I don't ever see anything like planting devices. Although some parents have planted devices in backpacks and sneakers and things like that that will record, usually without the child's knowledge, but it could be with the child's knowledge too. I've never seen it, but I wouldn't be surprised in these kind of cases. But any attempt to get information from you or your new relationship and to relay it back is just a bad move. It's bad for the child to begin with, but it's also a very strong sign that alienation either is occurring or that you're going in that direction. So, and here's the question that I touched on before: is alienation a deliberate act? And the answer, simply from at least psychological aspects, is no. That it can happen unconsciously. That the certain actions are reinforced to the children that the other parent is dangerous or wrong. Now, I personally don't necessarily accept this in at least all cases. I think some of them are intentional. I think they're usually a result of angry parents that are taking it out and incapable of seeing the harm to their children. But many, and probably most, do fit this definition that it's not an intentional act. Next question, probably one of the most important. What do you do if you are being alienated? And it's important that you act quickly, because alienation takes a very long time, but so does the court system. So you want to look at things like getting therapy or other kinds of intervention. Now, the interesting thing about alienation is there are actual therapists who will do like anti-alienation therapy with children or reunification therapy with children. There aren't that many that do the specific alienation, and some of them are actually very rigorous and intense that I don't necessarily recommend that either. But alienation is challenging to reverse, and it often does require a very rigorous program. But you want to start looking into them right away, because you want to stop this. What the next part will be, you want to stop it as soon as you see that it's occurring. Because I always say, and a lot of people get offended by this, but I say alienation usually takes two people. And that's because the person who's being alienated doesn't act quickly. Because alienation, like I said, takes a very long time. It begins quickly, but to be really effective and deep-rooted takes a while. And if you act before that, it's not usually likely to occur. So next tip on my slide is going to be actually, I think, what I just said. And that is, the longer, well, it's supporting why I said, the longer the belief exists in the child, the more likely it's going to become permanent. Oh, sorry about that. Don't know what that is. Got a computer prompt. All these updates are killing me. Now, next, also, children can become rooted in this dysfunctional behavior. Obviously, children are impressionable and they're sponges. So when they're being taught by their primary role model how to act in a negative, aggressive way towards a parent, and it persists, it's going to get ingrained. And that's another reason why you definitely need to act as quickly as you possibly can. You don't want to force it to the child. When I say act quickly, I usually mean with the other parent, with therapies, and in the court. If you force a child, you might reinforce to that child the things the other parent is saying, that you're aggressive or that you want to take them out of their activities and have fun, or that you're running them through the court system. All these things will come up. You want to have positive times with your children or child and reinforce that. It's the other parent and the court system that you want to use to remedy the problem. Next, along these lines, you never want to let the children make these decisions. And this goes back to not only whether or not they're going to come to the events in parenting time, but also whether they're going to go to therapy. A lot of parents will say, oh, I don't want to push my child. I'll just move my slide back. Okay. But everybody pushes their child. I always say, well, if they said they didn't want to go to the dentist, you'd make them. If they say they don't want to go to school, you make them. If you want them to go to therapy, you make them go to therapy. It's just as simple as that. And you have every right to do it. And if you have a court order for custody, you can get these enforcement actions. They're completely enforceable. if she or he or she is violating them, you have to get an order for contempt and ask for this therapy. But it's all going to be within the control of you and the court system, whether your child wants to do it or not. Now, along these lines, let's talk a little bit about what the court may do. The court has great authority when it comes to custody issues. Unfortunately, they're not fast to act on it because the bad act of a parent doesn't necessarily mean the child should suffer. So ultimately, they're still going to look to the child's best interest. So if a mother or father, sorry, no offense, but I do men's and fathers' rights, so I generally speak from that filter, is found to be alienating, that doesn't mean they're going to just take the custody and change it, but they can. It depends on the process that you go through. If you start early enough and there's a history that develops in the court because you're doing this for over a year time or year and a half time, then a change of custody is quite likely because the court will see that the other parent is simply intent on frustrating your parental rights and the court's orders. And that's also very important. So they can do obviously a lot. They can change custody. They can change parenting time. They can give up parent or make up parenting time. They can assess for legal fees and expert fees and things like that. Now, obviously, one thing they can't do is change the attitude of the child, but through the process of terminating the alienation and reinforcing positive relationships, it should solve itself automatically and naturally. File an application with the court as soon as you're having a problem. The court system, very slow, very unresponsive, and in many cases, unsympathetic. They have a high volume cases no matter where you are, at least in New Jersey. They're going to send you in the hallway and tell you to settle your issue regardless of what it is. But the key to acting in the courts with alienation is to go back, unfortunately, repeatedly. File a motion or an order or motion to hold a person in contempt for not giving you parenting time. Get an order. As soon as that's not complied, file another one. Now, it's a pain in the ass and it's expensive. Even if you're not hiring an attorney, paying filing fees, you're probably missing work. You're taking off to go to court for things. It's stressful, but there's no other way than to have this record start to develop. And each time you go back on a subsequent application, attach the original application, or at least the relevant portion, because you don't always have the same judge. And even if you have the same judge, they're not going to remember your case, and hopefully they have time to review it before you get up there. But if they don't, or they don't review it well, they're not going to know that there's a history. And the history in alienation, as well as the history of the legal process, is always going to be very important when establishing to a judge that there should be extreme remedies like changes of custody. So let's talk about what you need to do to document these issues so that you can show them. First is you want to keep records of your interactions with your child or children. And I don't mean necessarily videotaping and taking pictures, but that is a good start. You should do that. It's also good just for your long-term memories to have them. But you want to keep calendars of times that you had them, times that you were denied time, things that they say when you're together, things that the other parent says when you're either communicating or receiving messages. Take screenshots of text messages, voicemails, emails, everything like that. I also usually recommend that you try to create some internal channel for this. I'm not a big fan of text messages when you have this kind of problem because they're hard to reproduce because there's thousands of them and you have to take a screenshot. My advice when it comes to this, maintaining communication records, is to set up an email with internal email boxes, inboxes. So instead of just having inbox, I would have an inbox that says extracurricular activity. I'd have an inbox that says missed parenting time, one that says pick up and drop off problems, whatever it may be. So every time you have an email communication with this person, you slide it into that box so that when the issue comes to have to be presented to the court or to a therapist, all I have to do is click on that mailbox or that inbox and print all the emails. You're not going to be searching through 300 emails to find the one that has like the long thread that you have to narrow down. You're not going to be printing out 100 text messages from Verizon and having to cut through it. It's a much better way to organize each issue, and it's simple because you're going to be emailing anyway. It's just you slide them at the end, and you keep everything in different compartments, categories. Along with what I said about keeping records of interaction, keep records of your activities, your involvement, your children's friends, their teachers, any activities they tell you about that you know they're interested in engaging in, so you have an idea of what they're doing, even when they're not with you. You want to have as many facts about the children's lives, one, so you can be involved in it, but also when you find yourself in court, the other parent is going to say that it's your fault, that you haven't been involved, or you haven't been around, or you didn't try hard enough. And having all of these records that you show to the judge will show that you have been, and that the courts always have to choose between one person. Usually it's who's more credible than the other. These records will make certain that you are that person. So next, let's talk about what you do with your child. How do you address it? It takes a lot of care. This is a sensitive issue because to the child, I don't want to use brainwashing, but their minds, their concepts of you are being changed. And that's something you have to walk towards very gently because you don't want to reinforce or harm the child in any way. You don't want to challenge a child, tell them that he or she's lying, or that that you're being treated like they're stupid, because they're going to get defensive, they're going to get upset, and they're going to believe that what the other parent is saying must be true because you're acting like that. So trying to use sort of brute force is not going to work. It's going to actually work just the opposite, both with your child and in court, because you're also going to arm the custodial parent with examples of why maybe the child doesn't want to be in your care, or why you're considered to be unsafe around the child, which will be the things you generally will hear. I don't recommend getting angry or punishing them. Now, getting angry may take some more control than you have in many cases, and I know this is a difficult issue for most people when they're losing time with their child. And sometimes it's not even at the child that you're angry, but your anger comes out because they're the only person around. It's not going to help. You have to make sure that the child understands that it's not his or her fault. Without telling them what you feel their other parent is doing, you can't just say, "Oh, well, your mom's trying to alienate you from you," because it violates what I said before. It would make you look like you're trying to alienate the other parent. So let them be heard. Don't lecture or blame them. Listen to them. Give them respect. I know a lot of people believe that children aren't sophisticated enough to understand these concepts, but sometimes, and more often than not, they are. They just don't have the language for it, and that makes it difficult to speak to them on an intellectual type of basis. So you want to just be gentle in approaching it so that you don't push them in the wrong direction. Remain calm. Document what's going on with the child when you're having these discussions, but always remain calm. And I say that because in the slide that I just put up, pushing buttons is very common. Normally, most relationships that have a child, they know one another very well. Whether they're together for a long time or not, they know each other very well. So they know what buttons to push. In many cases, they're the ones who put the buttons there. The relationship was long enough. So getting angry in response is only going to reinforce what they're saying, both to the child, to the court, to the therapist, anywhere that you find yourself. You need to be, unfortunately, on your best behavior. And that's going to be very challenging because, like I said, throughout this whole presentation, this is probably one of the most challenging issues that you're ever going to face with your children. And sometimes your emotions get the best of you. But you can't let it happen. You can't let them see it. You can't let the other party or parent record or document it either, because that's just crushing for you. All right. Now, I'm going to talk a little bit about an area that's outside of my experience. So I'm not holding myself as if I'm any kind of psychologist, psychiatrist, but the concept of parental alienation is in the DSM-5, which is the book that really explains and diagnoses psychological psychiatric disorders. But it's referenced, it's not specifically cited as a syndrome, because I'm just going to put these up. The term doesn't exist because it's not necessarily a psychiatric or psychological disorder that the child has. They're usually part of your birth or your development, or as a result of a physical accident that may change the physique of a person's brain. But mental disorders, psychiatric disorders are internal. This is being caused by an outside source, the other parent. So it's not really considered a psychological psychiatric disorder, but it is referenced as in other forms. And that's important because, let me move my slides over here. Because it means that the recognizing exists. It also helps the judges and your therapists understand it, so that at least there's some reality that it exists, that it happens. Because it's also a term that people throw out all the time. It's unfortunately overused, in my opinion, because true alienation does take a long time. When you start seeing the signs of alienation, maybe you have it, maybe you don't, but people throw it in, and it's kind of like the boy who cried wolf in a lot of cases, where it's really not genuine yet. Now, I'm not saying that if you see it that you shouldn't be acting for it, but you don't necessarily want to jump in saying it so early, because remember, like I said, you're likely to find yourself in court often. So if you come in every time, here she's trying to alienate me, here she's trying to alienate me, here she's trying to alienate me, it's going to be like the boy who cried wolf. The courts are going to stop listening to it. Now, if you start out by saying, I miss some parenting time, I want to make up. I miss some parenting time, I want to make up. She's being unreasonable by not allowing me to have my vacation time, I need to make up. Now, when you're going in the third time, the fourth time, you want to start saying, this is a process that he or she is working to alienate me. And you support it by the other 2 or 3 applications that you've been attaching, if you listen to what I said in this webinar, so that they can see the history and the development. Now, just to close out on this topic here, and this is actually coming to the end of the webinar. I'm not really sure how much time we spent on it, but hopefully enough to keep you interested. They did recently, the co-authors of the DSM-5 did make clarifications that it is firmly covered by the DSM-5, but again, not as a psychological psychiatric disorder. And that's just important to know this, because you don't want to go into court and say that the other parent is a bad person. The child needs to be ripped away because they're being harmed by the other parent. You're better off addressing it as if it's a psychological type of disorder, because courts don't like to hear 2 people ripping themselves apart, because you're going in saying, he or she's alienating me, and they go in and say, no, he's just unreasonable and impossible. It's better to go in and say, Judge, we're having a problem because I believe that my child is being alienated, and that my, I'm going to just say ex-wife, I don't want to hear about it, but my ex-wife doesn't realize that she's doing it, so therefore the court needs to get involved to make sure that it doesn't continue. I think it's a much better approach. The court will believe it more likely because you're credible if you're not in there trying to attack the other side. Because you have to realize most of the cases that are going into family court are highly contested, and otherwise it wouldn't be there. They would have settled through mediation or some kind of ultimate dispute process. So the fact that you're before a judge has the judge realize that there's a high conflict issue, and they see thousands of them. I think that they get a little jaded by it, and I think when you go in and you say, I'm being alienated, they're hearing the 2,000 other people that made that claim over the last year, and they're, I don't want to say tuning out, but I don't think they're going to really pay attention to it. I think you need to package it in a way that explains what is going on, and that you're not blaming anybody, the other parent, the child, the court system, but that it's a real problem that needs to be addressed. That really is the bulk of the information. Like I said in the beginning, it's not a lot of legal information about alienation, but it's really an important issue. I wanted to make sure that you have some guidance if you think it's going to occur. So I'm going to stay on here, see if I have any questions. I see a question. I just can't seem to open it. Okay, so I'm going to just read the question out loud, and then if my answer doesn't cover it, just type some more. So there's a few things here. Is there a way to prove that the alienating parent is a you say narc, but I'm assuming you mean narcissist. If we can prove the alienating parent is a narcissist for sure, does it hold any value in the family court? My wife's attorney is supporting my ex to the fullest with all kinds of. Okay, so I don't know if this is all part of the same thing because it shows up in my window. So I'm going to read through it and then see if I have to break it up. My wife's attorney is supporting my ex to the fullest with all kinds of falsifying information, threatening of contempt. Is there anything can be done against these types of attorney? Well, yes. Well, of course. First of all, don't get wrapped up in attorney letters. I call them nuh-uh letters. You get a letter saying you did this and you did that and you stole this and you didn't comply with this. And then you write back and your attorney writes back and you pay for it. And the letter is, nah, you did this. Your client actually did this. There are ways. More often than not, these kinds of letters that you're receiving are being written for his or her client to read, to satisfy his or her client, to make them think that I'm going to stop going to he or she. I'm just going to use like he and one, so that I don't have to be grammatically correct. He's writing the letter so that his client feels that he's doing a good job and he's a strong fighter and he's really out there advocating. But letters are pointless. They don't accomplish anything. They're not admissible in court. But another thing to realize also is I believe that people get lawyers that are just like they are. Otherwise, you can't work together. So if you're impossible, you're getting an impossible attorney. If you're a narcissist, you're going to get one that's narcissistic, or at least willing to support a narcissistic client. So don't expect they're going to be a break in communication or there's anything you could do. Best is to ignore it. It drives them crazy when they're sending letters. And usually if a lawyer's sending it, they're paying for it and you don't even respond. Or you respond with like a one sentence. I do a one sentence letter sometimes just to irritate people. I'll say, your letter of September 26th is untrue, period. And I send it over. Because they're paying for this long-winded letter, 3 pages of all the things you didn't do, and they get one sentence back in response, and it's basically saying like, I don't care what you have to say. And unless the letter is addressing something, you don't need to worry about it. I say this because this is very common. People get letters. I just got a call from a person wanting to meet yesterday. He got a letter from a lawyer, and he said he had 10 days to respond. And it's probably one of those intro letters. I've been retained to represent your spouse in a divorce. Respond in 10 days or I'm going to file a complaint. First of all, they don't usually do it in 10 days because they have other cases. But they have no authority to make you do anything. Lawyers can't do anything without a judge involved, and it's very long and slow. So my advice is just to ignore the letters. Even if they say something significant, you might want to address it on your own, but you don't have to respond to them. I wouldn't play their game. Let's see. Oh, I think I just messed up the PowerPoint. So I'm going to stop showing my screen for a second so that I can fix. Oh, a lot more just came up. Hold on. I don't know why my slides aren't coming back up. Okay, here we go. Let's show the screen again. I want to look as competent as possible. All right, so let me see if I can expand this window. Let me expand the window, but I see that there's some other statements or questions. I really want to make sure I get to them. Just give me a second, people. All right, we're good to go now. So I'm going to continue reading down, see a couple of things posted. So I think the first set of questions was from the same person, and hopefully I answered that. So I'll start reading what is next. On the plaintiff, Mom and I have physical custody Father's claiming, P.S. I know I have not done this. Actually, my ex has NPD, which is a narcissistic personality disorder. And I believe this is just another tactic he has come up with to continue punishing me for the divorce. I filed for divorce in late 2000, and we've been in and out of court for 8 years. And it does sound like you got a narcissist on the other side. We are considered high conflict. Can you offer advice on how to protect ourselves against these false allegations from a narcissist using against us? Well, yeah, God, I could spend days telling you how to deal with a narcissist. I recommend that you go to my website, not my website. Well, my website has it too, but my YouTube page is probably more helpful. And watch, well, actually either one of them, I guess, MicklinLawGroup.com or Brad Micklin YouTube. I did a couple webinars on divorcing a narcissist, and I know that it sounds like you're already divorced, but it's really the same. It's about litigating with a narcissist. It's always the same, whether it's just you have one issue with like custody or you have 10 issues in a divorce case. Watch those webinars because it's really a step-by-step process you need to take. Part of what I was saying before to the last question about ignoring letters, you ignore things that are out of court, but in court you have to respond appropriately. So I would say watch the webinars. You can always message me after. This is one of the areas where I'm not allowed to say specialized. New Jersey doesn't let us say specialized, but where I concentrate. So the webinars I've heard have helped a lot of people. So I recommend that you watch those because I really wouldn't be able to answer that question that simply in this kind of a setting. But if you have any questions after you watch it, send me a message through whatever forum you see it, and I'll address any other questions you have. Oh, apparently she watched the webinar. Okay, so, and there's also a mention in here about this person that contacted me, but then realized that I deal with men's and fathers' rights. And that is my concentration. I do still represent some women if I think that my experience and concentration will help their case. Because obviously, if I understand what men's interests and issues are, then I can help some women when addressing that and find creative ways to resolve highly contested cases. My specialized experience in narcissism is often where I represent women because 90% of men or 90% of narcissists are men. So I'm not currently 100% of representing men, but I limit it to only if I really think I can help a woman's case because of that concentration. So I don't just take anyone. I don't recognize your name. You said you had contacted us. Maybe it didn't come my way, but I always recommend at least having a consultation. I do consultations, and I do charge for my consultations, which many don't, but I do it because I make sure that you leave with value. I review whatever documents you have before you come to me, tax returns, court orders, restraining orders. I run support numbers when it's a divorce consultation so that you leave here knowing what you need to do. Whether or not I ever see you again, it's not about hiring me. It's about getting value from our experience. So if you are interested, you should call back up. I do think, based on your comments here, I can probably help you. And if not, I wish you the best of luck. But I would consider it. So I'm going to tap down, see if there's anything else. I'm going to take a quick look. Yeah, so one of my good clients is saying that her teen sounds like what I described, but that's because all teens. Oh, you said preteen, but yeah, no, I see that you're joking. But yeah, they're just wait. If it's preteen, it gets even worse. I'm going to see if I don't know how I can check. Oh, I can scan up and down. So I don't think I see any questions over here on Facebook. Oh, got some family I haven't spoke to in a while popping in here, which is great. I love that. So I don't see any other questions. So I think with that, I'm going to sign off. You can always email me, brad@micklinlawgroup.com, which is MICKLIN. I always will address any answers. If you see me through some kind of social media forum, you can message me through that platform also. And I will always address your concerns. With that, I'm going to wish you a good night and sign off.